Welcome back to the Elias Macko Show. We have just a little bit of an update. We were speaking with Robert Fife earlier from the Globe and Mail. I asked him if he had heard anything about when the Conservatives will release their full platform. And now we do have some news on that front. So Pierre Poilievre just announcing this morning that the Conservative Party is going to release their full platform tomorrow. Tuesday is when that full platform will come out. Of course, the Liberals released their full platform over the weekend. Now let's talk about one promise from the Conservative platform that has been announced. Conservative leader Pierre Poilievre wants to use the notwithstanding clause to reinstate a law allowing consecutive life sentences for mass murderers. Of course, the Supreme Court ruled that would be unconstitutional in 2022. Some legal experts warn this move would undermine the rule of law, erode charter rights, setting a dangerous precedent. Should point this out. Liberal leader Mark Carney called Poilievre's plan a dangerous step. But let me point this out to you. Over the weekend, in that Liberal platform that was released, I'll point this out in their crime and justice section of their platform. This is in the Liberal platform. They say they will make moves to, quote, allow for consecutive sentencing for car theft with violence or car theft involving a criminal organization. They will also allow for consecutive sentencing for, quote, serious and violent offenses. So it seems both of the leading parties here are in favor of some sort of consecutive sentencing. Let's go to Frédéric Bérard. He's a constitutional lawyer and from the firm GBM. Frédéric, welcome back to the program.
Hello.
So I want your take, the legal mind take, on the use of the notwithstanding clause for something like this.
Well, that would be quite dangerous, to be frank, because it would be the first time that the federal parliament would use the notwithstanding clause. It never used it since 1982 as a political statement. And the political statement is the following. Rights are rights are rights are rights. You don't touch those rights for whatever reason. And in this particular case, the Supreme Court was clear that this was unconstitutional for a few reasons that are, in my opinion, very legitimate. In the sense that we need to keep the judicial power in charge of evaluating those sentences. So I guess that Pierre Poilievre's bet right now is to appeal to some kind of an electoral frustration about those sentences, but I think that is quite populist at this stage.
What are the things that could be done aside from using the notwithstanding clause? Because there have been numerous rulings, right? Mandatory minimums, a whole bunch of rulings where, the Supreme Court has ruled, no, we can't be as tough as the government would like in certain situations, right? And of course, that's why the Liberals walked back some things, right, as they got Supreme Court rulings. But what could be done to be, quote unquote, tougher on crime while still respecting the Constitution and the Charter of Rights and Freedoms?
Well, it depends on what we're talking about. But, Pierre Poilievre said, for instance, that, we need those people to stay in prison for the rest of their life. As of now, they are freed after 25 years, even for murder. The truth is, this is a false statement. When you are convicted to prison for life, that means that you can stay for the rest of your life in prison without any problem. But we are offering in Canada the chance after 25 years, the chance to prove that you can be reinstalled in society and blah 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 blah, evaluated by a commission. If it works, good for you. If it doesn't, you stay in. Just remember the story of Valérie Fabricant, the professor at Concordia who killed some colleagues quite a time ago. He was convicted for life, right? And he's trying year after year to get his liberation. But the commission is saying, well, you're still a risk for society. You stay in prison, and that's it, and that's all. So this is what the Supreme Court was trying to avoid or trying to protect saying differently, in the sense that we want to keep that possibility to evaluate if a person is entitled to be liberated after 25 years, after 30 years, after 50 years, whatever, and that's it.
Yeah, and of course, there's a recent story out in New Brunswick of someone who was killed multiple people. It was three people, and they're now on day parole. Now, they haven't been fully released, but there's someone who did get life sentence. They've done the 25 years, but now are getting day parole, which I know is different from being outright released, right? Now, let me ask you this. So the use of the notwithstanding clause, I'm wondering about the argument that it's a slippery slope. In my mind, we have a check and balance on that front, right? Which is the voters, we vote in governments. If a government would go too far in the public's perception, right? You start with on the slippery slope, okay? You do something, use the notwithstanding clause against murderers, and then you use it again. You go further and further down the list. Isn't the check and balance that exists when it comes to the notwithstanding clause that at any time, every 4 years, you can vote out the government that uses it too brazenly?
Mm-hmm. Well, that's a very smart comment, very smart reflection, but I beg to disagree on this one, because in 1982, that was precisely the reflection that the constituents had, saying, well, if we use the notwithstanding clause, we will be punished by the population. But as of now, in 2025, that's the other way around. If you use the notwithstanding clause, you get some rewards during the election. Just recall what the Gouvernement Legault did with Bill 21, with Bill 96. They used the two notwithstanding clause, and they got the biggest majority in the next election.
Yes.
Just take a look to what's happening in Saskatchewan right now. They're using the notwithstanding clause to infringe the Constitution in terms of the LGBTQ community. They're thinking about doing the same thing in New Brunswick. In Ontario, Doug Ford did it to suspend the right to negotiate to close to 60,000 employees in the education sector. Take a look to what's happening in the USA. Most people do not care that much about the violation of the Constitution right now, because we're living in an era of populism, in an era where the civil rights are being infringed day after day, and nobody really cares about. And it's easy to use the notwithstanding because say, you know what? I'm going to take care of those murderers. Don't worry about it. And the day after, I'm going to take care about those Muslims. And the day after, I'm going to take care about those trans people. I'm going to take care about those itinerants in the street. I'm going to take care. And this is what's happening right now.
Okay. So listen, I'm happy you brought that up, right? Because you brought up the homeless situation. So this is really good. To wrap up, I'm going to ask you this question, right? Because there have been cases in Canadian courts with regards to homeless camps, right? Encampments. Yeah. And there is a battle. Like, let's say you live in the area, and then across from the street from you in a park, there is an encampment. We are seeing courts rule that it's the charter rights of those people who are in the encampments supersede the rights of the people across the street that live in their homes to not be living next to drug use and that kind of stuff. We've seen those rulings. Last week, there's a case in Ontario now where people are invoking charter rights to fight back against the government of Ontario because they passed an anti-bike lane bill, okay? So I just wonder if it's going both ways in the sense that that people are invoking charter rights way too frivolously, and then also on the other side, people may be trying to use the notwithstanding clause too frivolously. Are both sides maybe trying to use these tools a little bit too much?
It's a very, very smart reflection again, Elias. I would say that to what you just brought up. Don't forget that when somebody is invoking the violation of his or her right regarding the Canadian Charter of Rights, there are two steps with that regard. The first step say, you, the government or the parliament, is violating my right to this or to that, all right? The court says, okay, I agree. This is a violation of the freedom of speech, for instance. But the process does not stop there. I mean, you need to go to the second step. And the second step is Section 1 of the Charter, which is this violation respecting a just society? So Section 1 is a way for the court to decide, is there some kind of balance between individual rights and collective rights and the interest of society. We have this process, and this is a very important one. This is mandatory for the court to do so each and every time that somebody brings up the fact that his individual right is infringed. So all that to say that we already have this process. It's been working, you know what, quite well since 1982. It's probably not perfect, obviously, but it's way better than putting in the hand of some populist government the notwithstanding clause, say, do what you want with fundamental rights, and we're going to say nothing at the end of the day because the majority will probably be pleased with this or that, right?
Frédéric, listen, a lot of weighty topics to cover in a short amount of time. Thank you so much for joining us.
Anytime you like.
Okay, be well. That's Frédéric Bérard. He's a constitutional lawyer and a professor at Université de Montréal.